Well, thank you so much for having us today, and welcome to everyone who's joining. My name is Esther Barron, and I'm here with my colleague Darren Green. We're both from Northwestern Pritzker School of Law and part of the Donald Pritzker Entrepreneurship Law Center, and we're delighted to be here. We're going to be talking today about entity selection and formation. I'm going to start with just some of the reasons why this is important and why you should be thinking about it. And then I'm going to turn it over to my colleague, Darren, who's going to go through some of the most common options and some of the differences and advantages and disadvantages. I want to say that this is for all of you. We want this to be as helpful and useful to you as possible. So please feel free to ask us questions. You can throw it in the chat or the Q&A, but we will definitely save plenty of time at the end for your questions on any of the material that we cover today. With that, I'm going to get started on why this is even an important topic and why we think about forming an entity and also why timing is important. So just at a very high level, if you don't select an entity, and again, Darren's going to be going through those options in a few minutes, but you're running your business, you actually have selected an entity by default. So if you're running a business on your own, you're selling something, you're offering services, and you're doing it by yourself, you're a sole proprietor or you have a sole proprietorship. If you're doing it with someone else, if two or more people are running some sort of business for profit, selling goods, offering services, you have by default formed what we call a general partnership. And so when we say why to form an entity, we're basically saying why to not have a sole proprietorship or a general partnership and actually select what Darren's going to be talking about, a corporation, an LLC, some other choices, and actually file paperwork and create that entity. The biggest reason and the reason why we generally do not recommend sole proprietorships or general partnerships is because they have unlimited personal liability. They're also less attractive to investors, and Darren will talk more about that in a few minutes. I'm going to focus on this ugly thing I called unlimited personal liability, which we don't like. And that means any liability or risks that the business incurs are really the liabilities of the individuals. So if you get sued and you're running a sole proprietorship or a general partnership, the assets that are at stake, if someone wins, the third party wins, are your own personal assets. So your bank account, your house, whatever your personal assets are. By setting up an entity, you can protect your personal liability and make it the liability of the business, provided you keep it separate. And Darren will talk about how you do that. But I'm going to just share an example because sometimes it's easier to think about why this matters if you have a real world example. And so I'm going to share a story that actually happened to me probably about 10 years ago. A former colleague of mine called me and said, Esther, I don't think it's a problem. I think this is fine, but this isn't, she's a lawyer. She said, but this isn't really my area of law. And I know you work with startups more. So I'm just calling to confirm that my cousin isn't at any risk, that he's fine. I already told him I think he's fine, but I just wanted you to sort of agree with me so I can tell him he doesn't have anything to worry about. I said, okay, well, tell me what happened. And she said, well, my cousin, who's a real smart guy, he moved out, he went to a great college, he got his MBA, he moved out west and was working at a big consulting firm. And he worked out at a gym there. And there was a former kind of well-known professional athlete who was a bit of a, pseudo celebrity in that town. It was a smaller town, worked out at the same gym, and he got to know him. And he started training her cousin, this former athlete. And, he paid the former athlete, the trainer. And he loved it. He bragged to people at work, guess who my trainer is? This is great. People thought it was really cool. They wanted to work out with him too. So he said to the former athlete / trainer, hey, a lot of people at work that I work with think they're jealous that I get to train with you. If you want, I could connect you, and you could, if you want more business. And the trainer, former athlete, said, that would be great. I could use more work. And this has been really fun. So yeah, I'd like to do that. So this continued. He recommended people, they actually even set up a website so people could put in their email address. It was a very basic website. And this continued for a while, where he was sort of connecting this trainer to clients that he knew from his company and from business and from other, just people he knew. It got to the point where the trainer couldn't take any more clients. He was busy. He said, this is awesome, but my schedule is full. So please don't send any more people my way. I'm just saying no. So they were collecting like a wait list on the website, but really couldn't accommodate any more people. And this real smart guy, who's my former colleague's cousin, said, you know what, I have an idea. What if we got other trainers at the gym to help out, and they could use your training routine? You could sort of lay out the workout, and then everyone could still say they're kind of working out with you, because that seemed to be what people liked, is being able to brag that they were working out with this former athlete who I said was sort of a pseudo celebrity in the area. And they would pay you something. Like, you wouldn't get all of it, but we could get paid something. And I should mention, this whole time, her cousin was getting paid a small percentage of whatever he brought in. So maybe it was $10 a person or 10%. It was a small percentage, but it added up, and it was really good money for him. So the athlete liked this idea. They talked to some other trainers. They got a few trainers together in a group, put together a workout routine, and then had people training under sort of still this pseudo celebrities name, just working out with someone different. Well, this went on for a while. They're both making great money. They love it. Their website is collecting emails and phone numbers. This goes on for a while. But what then happened is, on a Saturday, the former athlete, pseudo celebrity / trainer picked up my former colleague's cousin to go to coffee. They had a meeting, and he said, guess what? I know you think you're sort of the business person, and I'm sort of executing, and we have our roles, but guess what? You are going to be so excited. I also have really great business ideas, and I've been working on something that I'm now going to surprise you with, and I hope you're as delighted as I am. I have signed a lease for a whole new gym. I've ordered gym equipment. I've met with a bank. I've taken, I've secured a loan for us, and you can quit your job. We can do this full time. We have a huge gym, tons of equipment coming, and we're ready to go. He was not delighted by that news. He was kind of terrified. It was a huge amount of money. The equipment was in the hundreds of thousands, all in, with the lease payments and everything else that had been incurred. And so this is when he called my former colleague, his cousin, and said, oh my gosh, am I liable for any of this? I had no idea he was doing this. I think it's not a good idea. I don't think there's anywhere near enough demand for this. I think we could lose all of the money, and am I on the hook? And this is where she said, I don't think so, because you didn't know about it, but let me call Esther. And my answer, unfortunately, was, no, I think he's got some real liability, because, going back to what I said earlier, I think by default, they had set up a general partnership. And the definition of a general partnership is when any two or more people come together to run a business and share the profit. And that's what they were doing. And when I went on their website, they even used the word partner. I don't think they meant it in a legal way, but it was there. So who knows what would have happened? There were some good arguments on the other side that maybe it wasn't a general partnership. I think the winning argument would have been it was a general partnership. The good news, in case anybody's worried, they were able to unwind most of this. So he did have some exposure. It was an expensive lesson, but not the crazy $100,000 lesson it could have been. And I say that not to make fun of this guy for not knowing, or not to say this is like, can you believe this could have happened? But more to say, it makes sense that this could happen. Of course, this could happen. People probably go into business together all the time, not realizing that they're creating a general partnership by default, and not realizing that they're taking on not only the liability that they create for the business, but also things that their partner might create for the business, contracts they might sign, inventory they might order, deals they might make on behalf of the partnership. partners are jointly and severally liable, so they're both liable, and it's personal liability, so it goes to personal assets, not just the assets of the business. If you set up a corporation or an LLC, you limit that personal liability. And when I said that to my former colleague, she said, oh, gosh, okay, I see. So general partnerships have unlimited personal liability. But if we set up a corporation or LLC, great, then there's no personal liability and it's just the liability of the business. Let's do it. How long does that take? Let's do it like tomorrow. And I said, well, we absolutely could. The problem is, any liability that's already been created is the liability of the individuals of the general partnership. Liability going forward could be the liability of the entity that you set up. And that goes to my next point, which is timing really matters. So as you're thinking about, well, when is the right time to move from a sole proprietorship or a general partnership and actually set up an entity? It's really, there's no magic line and there's no magic answer. But what we generally tell our clients is, when you're doing something that's like starting to create liability, that's when you want to have a liability, an entity set up. So are you taking money in? Are you signing contracts? Are you selling something? Are you hiring people? These are the types of flags that you should look at as indicators of when it would be appropriate and probably advisable to set up the entity, so that you're protected for anything that might happen going forward. So that's just a little bit on sort of why this is important, why we want to think about entity selection, why the timing matters, and why you may be actually running, a certain type of business association, a sole proprietorship or general partnership, without actually realizing that. So important to think about these concepts and decisions pretty early on. The good news, it's pretty easy to set up an entity. It's not that big of a deal. There's lots of really good options. And so I'm going to turn it over now to Darren, who I did the scary part. He's going to do the great part of like, and here's the answer. Here's what you do.
Thank you, Esther, and good to be here with all of you on this snowy day. As Esther suggested, forming an entity early rather than allowing a general partnership to form is generally a good idea, right? It's something we want to do. What we often hear from clients is, well, it's too complicated, or well, it's too expensive. I don't want to deal with it right now. We'll figure it out later. And the good news is it doesn't have to be any of those things. So I'm going to talk a little bit about the process to form an entity, where you would form it, and what type of entity you might think about forming. Let's start with the process, which is fairly simple. Creating an entity, what you actually have to do to create an entity, regardless of which type you ultimately choose, is fairly easy. You can form an entity in any state in the United States, and we'll talk about that a little bit more in a minute. But let's say you chose Illinois and you wanted to form an entity here. There's a filing you make with the Illinois Secretary of State. It's called either Articles of Incorporation, Articles of Organization. The name doesn't matter. It's generally a very simple form. It's like a one-page document. You provide a little bit of information. In Illinois, for example, you can do it all online now. So you don't have to print anything out. You can go to their website and you can submit right through the website. It might take you 15 or 20 minutes. It's quick. And it's a little bit of basic information that you have to provide. The fees are generally pretty reasonable. Illinois lowered their fees not too long ago. They're very competitive here. It's usually a couple $100, maybe a little bit less even, that you submit with your filing. And that's it. You make that filing with the Secretary of State either a day later or a week later, depending on how fast you ask them to go. You get back sort of a stamped copy. And at that point, you have an entity. Now, there are documents you might decide to create if you've got partners or like co-founders with you. Those aren't things you have to file with the state, though. Those are things you would do in the background. The actual formation of the entity doesn't take much time and doesn't cost all that much money, regardless of which state you choose. So don't let that be a reason that you don't form an entity. You can do it fairly quickly. So that's kind of thing one. I mentioned you can form an entity in any state you like. So where should you form? There's no one right answer. I'll tell you this. if you're based in Illinois and you're sort of operating your business out of Illinois, there's very little reason that you wouldn't form in Illinois. In all likelihood, you're probably going to form here. It's sort of easier and more cost effective if that's the case. If you happen to have a business where you've got co-founders that are living in other states and you're kind of spread out across the country, then you might start thinking about, well, is there another state which makes more sense because we're all over the place. Our business is all over the place. But for most businesses, if you're based here in Illinois, Illinois works just fine. You'll sometimes hear a lot about the state Delaware, which seems somewhat odd. It's a small state out east. Most businesses aren't based in Delaware. I'll mention it quickly, just so you sort of know the reason why, if you ever hear somebody mention forming an entity in Delaware. For companies that are going to be raising lots and lots of money, like millions of dollars, Delaware has a very old body of corporate law. They sort of created it many years ago, and it's very protective and it's very favorable to businesses that form there. And because of that, if you were raising money from investors, lots of money from investors, sometimes they're just most comfortable with Delaware because they know it. They've seen it before. They know how the law works. They know it's protective of them. So they'll sometimes try to push the entities in which they invest to be a Delaware entity. But again, most businesses aren't raising millions and millions of dollars, and most businesses don't have to worry about that particular issue. So unless you're that kind of business, and most aren't, again, Illinois is probably going to be a perfectly reasonable state. You can form the entity by filing with the Illinois Secretary of State on the Secretary of State website. And by doing that, you'll sort of minimize your fees a little bit. So that's sort of state of formation. Let's talk about the more interesting topic, or we find it interesting at least, which is what type of entity to form. Again, you can form in any state. It's easy to form whichever state you pick, but where should you form? Or what type of entity should you form? So there's there's actually many options, but a number of those options are not really likely choices. So we're not going to spend a lot of time on those. For example, there's a limited partnership, which you can form, but very few businesses, early stage businesses, choose that form for a variety of reasons. So we won't spend much time on that form. There's three sort of principal choices. There's the corporation, the standard corporation, which is also known as a C corporation. There's another type of corporation known as an S corporation. And there's a third type of entity, which isn't a corporation at all, called a limited liability company, or an LLC for short. You'll often hear it referred to as an LLC. Those are the vast majority of new businesses choose one of those three structures. 98%, maybe more than that, choose one of those three structures. So let's start with the corporation, which is sort of the standard, sort of one of the oldest forms of entity in the United States. Forming a C corporation, again, is very simple. You file an Articles of Incorporation with the Illinois Secretary of State if you're forming here, and it's the default form of corporation. So when you form a corporation, you start out as a C corporation automatically. So what are some of the benefits of a C corporation? One is what Esther talked about before, that liability shield that you want to build around yourselves as an individual so that you don't get sued personally. You're not risking your own personal stuff. C corporations work well for that. They provide that liability shield. C corporations also have some flexibility. You can have any type of shareholder. It can be an individual that owns shares, like you as a founder of your business. If you ever raised money from an investor and they wanted to invest through some sort of entity, that entity can be a shareholder. Your shareholders can be located anywhere. They can be located in Illinois. They can be located in other states. They can be located in other countries. It doesn't matter. All of that's permissible in a C corporation. So that's sort of a nice benefit. You can issue any kind of stock you want in a C corporation. Most founders, when you form a C corporation, you get what's called common stock, which is just basic stock to evidence your ownership. But if you were going to raise money, there's something called preferred stock, which is sort of a type of stock that investors like to get when they're giving you money for your business. You can do that in a C corporation. So all of these are benefits: flexibility around your shareholders, liability shield around yourself. All of those make a C corporation a good choice if you're going to form an entity. So you might ask yourself, why not just form a C corporation? Is there any drawback? And there's one principal drawback that you'll often hear about with a C corporation. It involves taxes, so we're not going to get too deeply into it. We run the other way from taxes whenever we can. But I'll cover it at a very high level, because you'll often hear the term double taxation. So let's just talk a little bit about what that is. When C corporations make money, just like when an individual makes money, you pay taxes. C corporations are treated a lot like sort of this fictional individual. So let's say you make $10,000 for the year in your C corporation. Well, at the end of the year, the C corporation is going to pay tax on that $10,000, just like you would if you made $10,000. You've got to write a check to the IRS, pay them for the amount you owe in taxes. Well, let's say you do that and you're still sitting on some money at the end of the year. The corporation still has some money left, and you decide, I want to take some money out as a shareholder. I'm going to declare what they call a dividend, which is the way that corporations give money back to their owners, their shareholders. If you do that and you take money out of the corporation as a dividend, that's actually taxed again. The IRS taxes those dollars. That's why they call it double taxation, because the corporation pays taxes, and then if the corporation distributes money by dividend to its owners, to its shareholders, they pay tax again. So in essence, a dollar has been taxed twice. So we don't know much about taxes, but we know we prefer to be taxed fewer times than twice. So it can be inefficient sometimes from a tax perspective. That's one of the principal drawbacks of a C corporation. So what do we do? Well, there's a second option. I mentioned the S corporation. An S corporation is nothing more than a C corporation that made what they call an S election. So you form your corporation the same way as a C corporation, but there's a filing you make. And that filing you make, that form you file, changes you from a C corporation to an S corporation. So let's talk a little bit about an S corporation. You get the same liability protection that you get in a C corporation. So that shield around ourselves as individuals, we still get it. So S corporations do quite well at protecting us, just like a C corporation does as individuals. S corporations address the other issue, that double taxation issue I mentioned with C corporations. In an S corporation, there is no double taxation. We won't go too deep into the details because it gets sort of boring. But at a very general level, when an S corporation makes money, the IRS sort of turns its head and pretends that it doesn't see that money as it relates to the corporation. It's called a flow-through entity or a disregarded entity. The IRS disregards it. It doesn't tax the S corporation. It only taxes the individual shareholders one time. Doesn't tax the corporation first. So that's called single taxation. We prefer single taxation to double taxation. So S corporations can solve that thorny tax problem that we mentioned with C corporations. So great, we get the limited liability, that shield in an S corporation, and we're only taxed one time in an S corporation. So you might ask yourself, why wouldn't all new businesses choose the S corporation structure? Because we're kind of getting the best of both worlds. Liability protection, and maybe better from a tax perspective. Unfortunately, not all is perfect with an S corporation. There are some issues with it. Principal issues with an S corporation involve a set of rules that are imposed on S corporations that are not imposed on C corporations. So what are some of those rules? S corporations have limits on the number of shareholders that they can have in their entity. Now, the limit is high. You can't have more than 100 shareholders. For most businesses, that's not an issue. They're not going to have more than 100 shareholders. But there's other issues. I mentioned that if you were going to raise money and issue that other kind of stock called preferred stock, you can do that in a C corporation. You can't do that in S corporations. You can only issue one class of stock. So S corporations often don't work if you're going to raise money from outside investors because you can't issue them the kind of stock that they want to receive. There's yet more issues. You can't have foreign shareholders in an S corporation. You have to be US nationals. So if I have let's say I'm starting a business and I want a shareholder in Spain, can't have a shareholder in Spain. There's yet more issues. I mentioned with a C corporation that anybody can own shares in a C corporation, individuals, other types of entities. In an S corporation, that's not the case. Only individuals, by and large, there's a few exceptions, but only individuals can own shares in an S corporation. So if I'm ever going to raise money from a third party and they want to invest out of an entity, which is very common, can't do it in an S corporation. So all of these rules combined make S corporations sometimes a tricky structure if any of those rules affect you. Now, if none of those rules are going to come into play with your business, maybe an S corporation can work. But those rules do become problematic for lots of early stage businesses. So what do? We don't want the bad taxation of a C corporation. We don't want to deal with all of these pesky rules of an S corporation. Where do we go from there? Well, there's a third option that I mentioned before that most of you have probably heard of, the limited liability company, or LLC. This is a structure that was invented probably 50 or so years ago out west, in a state where not many entities are formed. The LLC was basically the marriage of the best of a C corporation and the best of an S corporation. It was sort of like a greatest hits. Let's take all of the benefits and let's get rid of some of the negatives of those entities. So what does that mean? So LLCs, you get the liability protection that Esther talked about, just like you get in a C corporation or an S corporation. So your personal things you own personally should be protected in running your business. So that liability protection is number one. You get the flexibility of a C corporation in terms of the shareholders that you can have. I can, in an LLC, they're called members in an LLC, same thing as a shareholder. They just call them something different. I can have owners that are entities. They can be individuals. They can be located anywhere in the United States or in a foreign country. I can have any number of owners, members in an LLC. There's not that restriction on 100. The LLC does away with all of those annoying rules that we have to deal with in an S corporation. So we get that benefit as well. So we can have sort of any number of owners. There's no rules. We get liability protection. We also get single taxation rather than double taxation. So just like an S corporation, the IRS pretends that the LLC doesn't exist and doesn't tax it. It just taxes the owners, the members, right? They're just like shareholders. So there's one level of tax rather than two levels of tax. So that's a good thing. So the LLC is like the greatest of all of these things. So why not choose an LLC, right? Because it sounds like it solves all of the problems we've talked about. And the answer is you may well choose an LLC. LLCs are very popular for all the reasons we've just talked about. Many new businesses choose the LLC structure. It's a good structure for lots of types of businesses. To the extent there's drawbacks of an LLC, I'll give you a couple. One drawback is from a tax perspective. While they can be better, meaning you might pay less in taxes, they can be a little bit more complicated. There's something called a capital account, which is created in an LLC. There's something called a K-1, which is a tax form that all owners have to file each year in an LLC. So if you're going to run your business out of an LLC, it's a good idea to have an accountant, somebody that you work with for your business. You may have one anyway, but somebody that's worked with LLCs before, that knows how to sort of deal with filing for taxes in an LLC. So that's one thing you just want to be aware of. If you create one and you're not good with, I'm not particularly good with taxes. I wouldn't try to deal with LLC taxation on my own. I would need help. And most folks do, most founders do. So that's one drawback. The other drawback I'll mention, and I won't spend too much time on it because it doesn't affect most businesses. But I mentioned before, if you were going to raise lots and lots of money, you're the kind of business that was going to raise money from like a professional investor, what they might call like a venture capital investor. Venture capital investors, those big investors, they sometimes don't like LLCs or those types of entities for a variety of reasons. They're more comfortable with C corporations, namely Delaware C corporations. There's lots of reasons for that. I mentioned that just because you should sort of know about it. But again, for 99.5% of businesses, they're not going to raise millions of dollars from venture capitalists. And so that issue doesn't matter. If you're one of those businesses, it's something to bear in mind. For most businesses, not an issue. So so LLCs are popular. S corporations, if the rules don't matter to you, those can work. If the rules do matter to you, you're going to raise some money, maybe a C corporation can work. One thing I'll mention, and we get asked this all the time, when you pick an entity and you file with the Secretary of State, you file whatever document you need to form that kind of entity, we'll often get asked, am I stuck with my choice? If I've chosen that type of entity, is that it? Can I ever change? And the answer is, you're not usually stuck. It is easier than ever these days to sort of migrate from one structure to another structure. For example, if I form an LLC and it turns out I need to be a C corporation at some point for some reason, there's a filing you can make with the Secretary of State. You snap your fingers and you can go from being an LLC to a C corporation. Going from C corporation to LLC is a little trickier for a variety of reasons. It can be done, but there may be some tax issues that might arise. But if you find that you need to be a different structure, you can hop from one structure to another, usually fairly easily. So maybe you start as an LLC. Maybe that works for the life of your business and you can always be an LLC. Or maybe it turns out you are going to raise money from a professional investor and you need to become a C Corp. You can convert from your LLC structure to a C Corp. You can even move states. I can move from Illinois to Delaware. I mentioned Delaware before. If I need to have my entity go to Delaware, I can do that. Relatively simple filings. So you can move back and forth if you need to from one type of entity to another. So that's a very quick run through. There's lots of little nuances with the different entities, but those are sort of the high points for the three most popular structures and why you might think of one versus another. There are a couple of unique entities that we're only going to talk about briefly that are probably worth mentioning for some of your businesses. And Esther is going to touch on those before we get to Q&A.
And thanks, Darren. And I do see that we have lots of questions in the chat and the Q&A, and we are going to get to those. So thank you all for putting those questions out there. They look like great questions. So other choice, we're giving you the most popular choices. We're not saying this is the like absolutely exhaustive list of all of the entities that you can choose from. These are the most popular. There are some entrepreneurs that really are more social mission focused, right? So maybe a little bit less about making a profit and more about having an impact. And those may be better served through what we call not-for-profit corporation. And a not-for-profit corporation, it's still a corporation. You still submit articles of incorporation with the Secretary of State in the state in which you're setting up your not-for-profit corporation. But the differences there's some significant differences. One, there's some advantages, right? So the people that contribute money to your not-for-profit corporation, if you do it properly, can get a tax write-off. That the not-for-profit corporation doesn't have to pay taxes. But when you submit your articles of incorporation, you have some requirements. You have to submit what your acceptable mission is. So you have to have a mission that's been sort of approved by the IRS if you want to get tax exempt status. So you have to set forth what that mission is. You also have to agree to some limitations. So there's 7 or 8 different limitations you have to agree to, including, there's not going to be any personal benefit. You're not going to be doing substantial lobbying, and a few other requirements that you need to include in your articles of incorporation. Once your entity is set up, you're a not-for-profit corporation. Imagine that you submit those articles of incorporation to the Illinois Secretary of State. You're then an Illinois not-for-profit corporation. In order to get what I called, these tax advantages of not having to pay federal income tax and having contributions that people make actually be tax deductible, you have another step you have to take, which is applying that not-for-profit corporation has to apply to the IRS for tax exempt status. Sometimes you hear that as 501c3 status, and that application is called a 1023. So the not-for-profit corporation submits a 1023 application to the IRS, which lists, all of like why they're entitled to tax exempt status, what their mission is, why it fits into one of the categories. And then if the application is approved, then the IRS will grant tax exempt status under section 501c3. There's another big structural difference between a not-for-profit corporation and a for-profit corporation. Darren mentioned with a C corporation, the owners can get money out if the corporation distributes money through dividends to the owners who are shareholders. In a not-for-profit corporation, there are no shareholders. No one owns a not-for-profit corporation. It's really the public. It's for a public benefit. So if anyone owns it, it's the public that owns it. It's controlled by the directors. So every not-for-profit corporation has to have a board of directors or a board of trustees. And that's who controls sort of the strategy and the initiatives of the not-for-profit corporation. We could spend a whole class just on not-for-profit corporations. I'm not going to, although I'm happy to answer questions. Another option, let's say you're not totally just for profit, but you're also not totally for not-for-profit. You want to have a social mission, but you also want to make money. Because one of the other requirements of a not-for-profit corporation is if you decide you don't want to do it anymore, you can't take the money out. You have to distribute it to other not-for-profit or tax-exempt entities. So you don't get to ever take the money out, other than in the form of reasonable salaries or compensation. So let's say you're sort of in the middle, you're a hybrid. You want to make money, but you also have a really important social mission. So one way you can do that is just to have a regular Delaware C corporation that gives money to a charitable cause. And with certain limitations, that's okay to do. And many for-profit corporations do that. But if it's really more integral to your sort of mission and sort of part of the fabric of how you want the business to be viewed and how you want to message it, you can set up what Darren was saying, or these sort of newer entities, kind of a hybrid entity, which is a public benefit corporation. And a public benefit corporation is a for-profit corporation. It's supposed to make money there are shareholders or owners, and the company is supposed to and has a duty to try to make money for the shareholders, make decisions to make money for the shareholders. But they also have a second duty, which is to further an important social mission, which they actually set forth in their articles of incorporation. And so those are a little bit more complex because you're balancing when my decision, would be make less money for my shareholders, but be better for the environment. How do I weigh that? And there are some rules and tests for how do you make decisions that sort of meet both constituents, your shareholders who want you maybe to make money, and then your social mission that you're committed to by putting in your articles of incorporation and by setting up as a public benefit corporation. How do you balance those sometimes conflicting interests? Not always, but sometimes. So that's another newer option. It's not available in every state. It is available in Delaware. But that's a newer option that's come up in the past few years. We often refer to those types of entities as having a double bottom line, right? Like one bottom line is to make money for shareholders, and one bottom line is to contribute importantly to whatever the social mission is that the entity has committed to in its articles of incorporation. So that's a little bit on those other choices. And now we have lots of questions, and I want to try to hit those questions. And there was one on not-for-profits that I want to just start with and make sure I answered that question. Yeah, I think it was how is a not-for-profit taxed? And so if you get the tax exempt status, then you can avoid federal taxes. But again, that's creating the not-for-profit corporation, but then very importantly, getting the tax exempt status from the IRS through the 1023 application. And then Darren and I are just going to go back and forth and answer
Yeah.
questions.
Yeah, thank you for all these questions. I see them in both Q&A and chat. That keeps us on our toes. We can look back and forth between both. So keep them coming. We'll answer as many as we can. So I see a question here. What if you start as one thing, but you go in the direction, your business changes? So you start a business, you form an entity, and then the business changes into something else. The question is, do you start another entity, or can you change the name? And that's a great question. So the short answer is, let's say you start a bit, you form an LLC and you're running a business out of that LLC, and then you do what they call a pivot, right? You go in a different direction. You could keep running the business out of that very same LLC. You're allowed to change the name. It's a very simple filing with the Secretary of State, a small fee, and you could change the name from whatever the original business was to whatever you want to call it in the future. So the answer is yes, you absolutely can keep the same entity for all of them. The one thing you'd want to keep in mind, though, we've been talking a lot about liability protection. So let's say with that first business, you have some concerns with something that happened. One of your customers is unhappy, or you had a dispute with one of your vendors or your suppliers, and you're fighting about a contract that you signed, and maybe you're going to get sued, or maybe the entity is going to get sued, or maybe the entity wants to sue them. In that situation, if you were starting a new business, it might make sense to create an entirely new entity that has nothing to do with the first one, because you want to leave the liability in that first entity. If you just start running a second business out of the same first entity, while you might save a little money in your filing fees by not forming a new entity, if there's liability that presents itself from that first business, your new business is now at risk because it's owned by the same entity. They can go after the new business's assets. So unless you're comfortable that there's no issues with that first business, you kind of wound it down in an orderly way, nobody's upset, there's no threat of a lawsuit, then sometimes starting a second entity makes sense just so it's clean from a liability perspective. You don't have to worry about issues from the first business coming back to bite you in your second business. But that's a great question. I'll turn it back to Esther to choose another question.
Thank you. So I'm going to go back to, I was looking something up. So I'm going to talk about a couple of you have asked about board of directors, and specifically board of directors with respect to not-for-profit corporations. You generally, at least in Illinois, you'll list who the board of directors are in your articles of incorporation. You have to have at least 3 directors in Illinois that live in Illinois for an Illinois not-for-profit corporation. And those are the directors that make the decisions for the organization. They might hire an executive director who's going to run the business on a day-to-day basis. But at a high level, sort of at the strategic level, the board of directors are going to be making those big decisions. And one of their biggest jobs is to hire and fire an executive director, a CEO, who's going to be doing the day-to-day operations of the not-for-profit. There's liability for directors of a not-for-profit corporation. Potentially, they have fiduciary duties just like directors of a for-profit corporation have. So it's important to, act in the best interest of the entity. No self-dealing, so you can't do anything that sort of benefits you over the organization. And I'll just give you a couple of examples of where sometimes directors get in trouble with not-for-profits where they're on their board, where it's like they pay themselves more than they should, or they get some advantage for being a director that's not really fair. It's not market. Let's say, here's an easy example. Like if the organization owns a piece of art that's worth $1,000 and they have the organization sell it to them for $500, they got a $500 benefit they shouldn't have gotten. So, things that are probably just common sense and pretty obvious, but there can be liability. But that's how the board of directors works. Usually the board of directors, you're required to have a minimum number of directors. And as someone steps off the board needs to replace someone so that they're in compliance. A lot of times they'll have more than the minimum number just so they don't ever get into a situation where someone unexpectedly steps off and they're below that minimum number. And with that, I will pass back to Darren.
Thank you, Esther. I see another question here. I get a lot of good questions here. So with an Inc. business, so a corporation, corporations typically have Inc. at the end of them. That's how you know it's a corporation. That's formed in Illinois in this example. If I'm doing, let's say, HVAC services in a different state, can we be doing them in a different state? So you're an Illinois corporation, and let's say you live near the border of Indiana, and some of your customers are in Indiana. Can you do that if you're an Illinois corporation? The answer is yes, you can. Regardless of which state you're formed in, that entity can do business anywhere it wants, any state that it wants to, or any other country that it wants to do business in. So it doesn't matter where you're formed. You're allowed to do business. You don't have to be an entity in a particular state in order to have customers there to do business. The one thing I'll mention, and we won't get too deeply into this, when you start doing kind of active business in another state, like let's say you hired people in Indiana. So let's say you live kind of near the border of Indiana and you hired people in Indiana. Every state has a set of rules. They call them doing business in rules. And once you sort of cross that line and you're doing enough business in a state, even though you're not formed there, they still want you to file something there. There's something called becoming authorized to do business. So if you're an Illinois corporation and you've got like a location in Indiana, for example, you would file with the Indiana Secretary of State a document saying, look, I'm an Illinois corporation. I'm going to stay an Illinois corporation, but I'm doing business in your state. And for me to be allowed to do that, I'm going to pay you a filing fee, and then I'm going to pay you a maintenance filing fee each year, a couple $100 or whatever it is. And that allows me to be doing business in Indiana. So while you can do business anywhere, at some point, if you're doing lots and lots of business in another state, you'd want to take a look at what the rules are in that state to figure out, do I need to be making this other filing there or don't I? But the general answer is sure. You can do business anywhere, regardless of which state you're formed in. And I'll pass it back to Esther.
I'm going to answer two questions because one's really short. Yes, so Illinois does have benefit corporation option, so that's a quickie. And then someone else asked, can you set up a corporation for selling a product and an LLC for selling a service or something? Like, can you have two different? And it's a great question because people often think you have to have a separate entity for every sort of business that you're operating. So the answer to that is yes, you can have a corporation for one thing and an LLC for something else. But I do want to mention that a lot of times people think that you have to have a separate entity for sort of every single thing they're doing. And there can be advantages to that. It also makes it pretty complicated. So some of our clients will set up either a corporation or an LLC and then do different things within that same entity. And so maybe they're selling handbags and they're doing fashion consulting and they're, providing consulting services and they're doing it all out of one entity. If you think about like a Procter and Gamble, think about how many different products they sell out of one entity. And a lot of times the way you do that and separate sort of, at least in your customer's mind, that these are different brands is through trademark law. And we're not going to get into that today, although I hope we're invited back at some point to talk about trademark law because we love trademark law. But you can have a different brand for each of the different sort of products or services you're selling under the umbrella of one entity. And that sometimes can be less complicated than having to sort of manage different entities. One reason and why that sometimes doesn't work for people and why they might prefer separate entities is if one business line has much greater liability than another business line, and you don't want to, you want to sort of protect the assets of one very stable, maybe lucrative business line from another that might be less profitable, but also create more risk. And so that would be then a very good reason to set up separate entities. But just keep in mind, you can do more than one thing from the same company, and you can communicate to your customers that these are different brands by having a separate trademark or brand for the different things you're selling. So hopefully that answers a couple of the questions that were out there, and I will pass it to Darren.
Thank you, Esther. I see a couple questions here, so I'm going to answer this question and also give you a description of another thing that sort of Esther and I do at Northwestern, because I think it's related to what you're asking. I see a question, is there help to set up an LLC? Another question, how do I create the articles of organization for an LLC? So the short answer is, let's say you were forming in Illinois. As I mentioned, you can go to if you search Illinois Secretary of State, Department of Business Services, you'll get to that part of the Secretary of State's website that deals with business. And you'll see all the sections, LLCs, corporations, all the things that we've talked about. And if you click on LLCs, there's a way to do it online where the Secretary of State, through this online intake form, will ask you a couple questions. What's the name of your LLC? What's the address of your LLC? There's something called a registered agent, which is how the state communicates with the LLC. Who's going to serve that role? You provide these 4 or 5 pieces of information right at the Secretary of State website. You hit submit, you give them a credit card to pay the filing fee, and there you go. You'll be able to form the LLC in fairly short order. Most states have that. Most states have a fairly simple way to do it at their Secretary of State website. But I mentioned there was something else I was going to tell you about in response to these questions. One of the things Esther, myself, and our colleague Steve Reed at Northwestern do is we have a class called the Clinic, the DPELC Clinic. And in that clinic, we do work for clients in and around the Chicago area, real legal work. So sort of serve as your lawyers for certain projects. We love working with entrepreneurs that we meet and making these presentations through the city of Chicago. All of the interesting business folks that attend these meetings. You can apply to be a client of the DPELC Clinic at the Donald Pritzker Entrepreneurship Law website. We can post that in the chat.
I posted it in the chat. The link is there.
Oh, wow. Esther's ahead of me. You can go to that link. You can submit an application. It's a very easy application where you say, here's our business. Here's what we need. Now we're mid-semester now, so we've got our clients for this semester for the most part, but you can submit your application now. You don't have to wait in the next semester, which will be sort of kind of after the summer. If your work doesn't need to be done immediately, we'll be accepting a bunch of new clients, and sometimes we can accept clients mid-semester if we have extra time, depending on how things go. But our fees are very reasonable. Namely, we waive them. So normally our clients, at least right now, we're waiving them. Our clients are happy with that. So if you have something, you want to form an entity, you want help with a trademark, that help with a contract, that type of work, feel free to submit an application through the DPELC link that Esther provided. And we can't take everybody. We've got limited number of students and faculty, but we do our best to take what we can. And again, we love working with entrepreneurs that we meet through these presentations. So that's another way you could get help with your LLC if the timing works for you. So feel free to submit an application. We love seeing them. With that, I'll turn it back to Esther.
Darren, should we briefly mention the Corporate Transparency Act? There have been a couple questions about having entities be anonymous. And I don't think we should go into a tremendous detail, but you want to just spend a minute talking about that?
Sure. Yeah. Being anonymous with an LLC or a corporation can be tricky. There's certain types of like Delaware trusts and these quirky entities that sometimes a business, when they want to be completely anonymous, they don't want anyone to know that they're associated with the business. Kind of hard to do that. Esther mentioned this thing called the Corporate Transparency Act, which is very new. It just went into effect literally a week and a half ago, at the beginning of this year. That's a federal law. It's not a state of Illinois law, but it requires, when you form any entity, it requires all the owners of the entity, all of the folks that can, on the board of directors and officers. There's a lot of rules that we won't go into. People are still figuring out what these rules are. But all of these folks have to make this filing and provide personal information to the Department of Treasury, the United States Department of Treasury. They're trying to make sure there's no fraud being committed through new entities that are forming or even existing entities that are forming. So anonymity is a little harder these days because you have to share a lot of information with the Department of Treasury. Now, the Department of Treasury, when they get your driver's license or your passport or whatever you submit, they're supposed to maintain confidentiality. Only certain folks can see it, but you can't be completely anonymous anymore because you got to share this information with the United States government. So that's just something to bear in mind. You can search Corporate Transparency Act. There's a lot being written about it by law firms and by other folks that deal with entity formation. So you can learn a little bit about it, but it makes anonymity a little bit trickier these days than it used to be. I'll turn it back to Esther.
we're almost out of time, and we have a couple questions on trademarks. And so I'm not going to go into a ton of detail other than to say a trademark is really your brand. So if you look around wherever you're watching this Zoom from, I have like Tate's cookies sitting right in front of me, tempting me. So Tate's is, a brand, Starbucks is a brand, and you protect those brands through trademark law. The best way is to get a trademark through the United States Patent and Trademark Office. I'm going to say two things. One, we have a really good video on trademark law on our website. So I had put a link in chat to get to our application. On that same website, there's a video Darren and I did on trademark law, if you're interested. And usually we get invited back, hopefully we will this time, to do a workshop on trademark law. So if you're interested, please be on the lookout for that. Do we have time for one more question? I'm looking to see.
Probably squeeze one more in.
I like that question.
One, if you'd like me to take it.
Sure, go ahead.
There's a lot of questions about sort of personal liability and kind of shielding yourself. And I see one, for example, I have a limousine company. I have 2 cars in my personal name because I'm getting a better interest rate that way. Does that affect me personally? And so obviously we don't know all the details around the limousine company. We can't provide specific legal advice on that, but at a very general level, if you own assets in your name personally, whether it's cars for your business or like a piece of equipment or machinery that your business uses, if you own things personally, there generally could be some personal liability, right? If there's an issue with a car or an issue with that piece of equipment, you're the owner of it. Depending on how that's set up and how it's structured, you might have personal liability. It's generally safest for your entity to own its business assets. So that if there's an issue with one of those business assets, folks are going after the entity rather than you personally. So there is some risk when you start introducing personal ownership of anything into your business. With that, I think we probably are time. Esther, do you have something?
I'm going to sneak one more question in because someone asked about getting fined for not setting up an entity. And I want to make sure we're being clear about one distinction. You're not going to get fined for not setting up an entity necessarily, but some types of businesses require licenses. And so I just want to make sure we're separating it's your choice what entity to set up generally for most types of businesses and most industries. But some types of businesses do require City of Chicago or Illinois or Cook County, wherever you're located, specific business licenses. And we're not going to go into that, but there's a great, the great information on the City of Chicago website on the different types of licenses that are required and available. So I would say that is a great place to start in terms of looking to see whether you need a license to avoid getting fined, which we all want to avoid. And I think we are officially out of time. Thank you so much for joining us. Darren, any last comments or words?
No, actually, I did see one person asking for a retype of the DPELC link because they couldn't see it. So I don't know if we want to try to post it one more time.
Oh, sure. Let me grab that right now. Maybe
it ended up in a strange place, but thank you all. These questions have been wonderful. And again, we hope to see some of you as clients of the DPELC clinic in the future or at future presentations.
Hopefully it went through that time, but I put it back in chat.
Thank you
Thank you, everyone.
Thank you to Esther and Darren for today's presentation. If you are a part of the BACP Entrepreneur Certificate Program, you can get credit for joining this webinar by by visiting chicago.gov/BACP certificate. Again, that's chicago.gov/BACP certificate. To learn about our upcoming webinars, please visit chicago.gov/business education. Again, that's chicago.gov/business education. And if you are driving, stay safe out there. Have a good weekend.